Hello, everyone, and welcome to One Civil Law, and I hope you're having a great day. Now, hypothetically speaking, there may or may not be a hearing for Sarah Boone today. It's on the docket for today, but I can't find a feed for it. So we are still struggling to try to find a feed. So please bear with me as I try desperately to find the thing in the background. And yeah, as I have some frustrating moments as I try to figure out multiple things at the same time. But know that we are here together in spirit decor or something, and we'll try to figure it out. And I don't even know hypothetically 100% what this hearing is supposed to be about. I'm not even 100% sure what the hearing is about, but that's okay. We can figure that part out as we go. Trial TV Live is postponed from yesterday. Yeah. Well, Trial TV Live has a feed up, sort of. Case management feed. So we'll go with that for the moment and see what we get. Let's see now. What is the? It's F3. That's what I thought was F3. Nope. Okay. All right. So I have a feed up, sort of, kind of, not really, and we'll go from there. I have trial TV Live, which may or may not stream. So yeah, we'll see. We'll deal with it as we go. How's everyone doing? Here I am, rock you like a hurricane. Here I am. What up, everyone? And I also have to figure out how to get your comments up on screen without streaming in Streamlab or StreamYard, because I'd really like the ability. There must be a plugin for OBS where I can get your comments up on stream or up on screen by clicking it or something. There must be some plugin that I can do, and I can bring up individual comments. That would just be great, because I'd like to increase engagement. And I think that'd be cool to be able to click on someone's comment and bring it up in OBS would be nice. I could obviously do it in StreamYard, but StreamYard costs like $40 a month. And I don't want to give them $40 a month just so that I can click something and it brings up the thing. That's annoying. So maybe while I'm waiting for the feed to start, I can try to do that. Streamlab can do it. To bring up an individual comment by clicking something in Streamlab. You can do that in Streamlab. I have Melon, which is their streaming software, but their streaming software is a little iffy sometimes. Yeah, because Streamlab has Melon, and I could stream it in Melon, and then I could click the individual things in Melon, which is now I think just called Streamlabs. They renamed it. But that still requires me streaming it through their interface. What happened to the one where you had it on screen? That was either StreamYards or Melon, which has been renamed, as opposed to me doing it in OBS. So those both are using third-party streaming tools. This is how you get Kurt to read chat. You better believe it. Thank you, Mandy. Yeah. OBS gives you more control. There's probably a mod for it because OBS like has everything. OBS, bring YouTube chat comments up on screen. Displaying YouTube live comments on stream. Twidget is, yeah, see, I knew there's a thing for it. Displaying and selecting YouTube stream comments in stream is pretty simple, although the feature's been completely blown out. There's very few software that can do that and none natively integrated into OBS. Software like StreamYard, Restream.io, they all cost hundreds of dollars. Most users simply want to display the comments. Well, now there's a solution. Twidget is a Windows application that can be used to display comments for free. Yay! Let's download it and install it. Twidget. Highlight chat messages on stream. Would you like to download this? I sure would. Yeah. Yeah. Install while streaming? You better believe it, baby. You better believe it. We're going to do it live. We're going to do it live. What's the worst that could happen? All of YouTube crashes. Yeah. Start signing using Google to you start using Twidget. Okay, I will sign in. I would like to do those things. Continue. Great. You have successfully logged into Twidget. Yay. Start. Stream connection. Enter YouTube URL. Okay. Hold on. Okay. Connect. All right. Connect. Live chat replay. Loading. And it loads and it loads and it loads and it loads, loads and it loads and it loads. Select. Unselect. Okay. So now I have a thing I can click on. All right. And then what do I do? Twidget uses browser source to connect to OBS. It runs a service which has the user-created browser source. Okay, you then open OBS, create new browser source, use the local, select your desired width and height, and refresh. Okay. No problem. Create new browser source. All right. Create new browser source. Let's see. Browser. Let's see. Stream comments. Okay. URL. Create new browser source. Okay. And all right. Mandy says it was postponed from yesterday to today. Thank you, Mandy. Kurt's computer science degree is coming in handy. Orange heart. You better believe it, Eddie. Thank you for your comment. Oh, man. Too fun. Too fun. The only way this could be better is if it was like integrated as a window into OBS, but at least this works. Yeah. Melanie Lewis says, yeah, Kurt. So now I can bring up individual comments one at a time and read them, which is good for the engagement. Yeah. Bees. Oh, man. All right. So we've got that mission accomplished. Yeah. For like in the Q&A. Well, I was asking someone, I was asking my mods just to prove I pay attention, right? I was asking my mods why some other streamer was having more success than me. And they said several things, some of which I do not want to adopt for me. But they said two things that I said, okay, those are two things that I could do. I said one of them was like to slow down when I'm reading stories, like on Thunderdome. And the other one was to like bring individual comments up on screen and then react to them. And I'm like, I can do those two things. So in the continuing effort of yours, Uncivil, wishing to be the best streamer he can possibly be, and his mods saying, here's some things you could do. And I'm like, these are two suggestions I can roll with. I'm like, how can I actually implement that? And now I've implemented it because that's cool. Ooh, and I get different formats of message. Ooh, I can do it in different ways. Ooh, interesting. So I can do it dark. Ooh, I can do it classic. Ooh, there's different ways I can do it to make it look neat. All right, let's try different ways. Let's try different ways of making it look. Okay, that's pretty cool. Ray A. Sun, this is why I follow you. That's kind of cool. With the red on white look, that's kind of cool. And then I can change it to a different look. Let's see what else we got. We got minimalist. And if I do that, okay, that kind of works too. Just minimalist, that kind of works. And then there's one that's dark. I think I might go with dark. That kind of works. This is why I follow you. I don't know. That's a little bit hard to read. Let's see what else we got. It cuts off at the bottom. I know. One problem at a time, man. One problem at a time, man. Look, just one solution at a time, okay? Let's go back to clean. Can you have it all on screen at the same time, Uncivil? Can you have the whole thing on screen? It's getting cut off a little bit, Uncivil. Man, you give the chat an inch. You give the chat an inch, and they take a mile, man. I'm so glad you have my comments. Can you make it a little bit different? Can you make it a little higher so it doesn't cut off completely? Needy people. Man. It's your job to want. I appreciate that. That's very good. Yeah. I think the clean is the way to go. The darker background's a little bit hard to read. I think the clean is the way to go. We'll do clean for now. Apparently there's a hearing ongoing, and it seems, if I'm understanding Trial TV's comments correctly, it seems like there's a trial ongoing, or at least a hearing ongoing, and it seems like they're recording it and then they're going to play it back after it's finished. So we might be here for a while. And then, yeah. Kurt's chat is nerdiest chat. You better believe it, Eddie. You better believe it. So this solution works. I don't know if it's necessarily the best solution, but it works. OBS, what would you call this? An add-on? At OBS add-on on display a YouTube comment. Let's see if there's anything else that will do this too. So Twidget is the one I do. Live chat over. I can show all live comments. That's easy enough. I can do that with a chat overlay. So if I want to do all chat comments, I can put that on screen. We've done that before. Twidget might be it. We'll stick with Twidget. It's very small. Well, I can make the whole thing a little bit bigger, but I don't think I can make the font any bigger. I don't have that level of control. I agree with you that the text is a little small. I could make the entire thing bigger. So I could do that, but then I'm not sure necessarily what that would mean in terms of like, if there was a comment that was long or something, but I could theoretically make the whole thing bigger. Yeah. So I have to be careful because I have to like make sure it's big enough for the biggest comment I want to bring on. So I can make it a little bit bigger. I can make it look like that a little bit, but I have to be careful because I only have as much white space as I have white space because it's a bodge. So, what can you do? I can't remember. Gifted 10 gift memberships to the channel. Thank you very much for the 10 gift memberships. Very much. I can't remember. We do appreciate everyone who contributes as well. Trial TV Live says, uncivil. We're currently recording the hearing and we'll release it as soon as we can. Noted. Thank you, Trial TV Live. Thank you for popping into our feed. I hope you're having a great day. See, this is the problem. Now the whole thing doesn't appear on screen. Let's see. What if I just change the width? What if I change it to like 400? Does that work? Yes, it does. Boop. There you go. Thank you, Trial TV Live. Appreciate your help. Boop. They're having tech issues. I hear you, Trial TV Live. That's okay. You keep powering through. You and me will make it together. You and me will make it together. As we try to bodge this thing in OBS. Thank you, everyone, for becoming a member. And then the other thing I could do too is if I switch to Streamlabs, which I'm thinking about doing, like instead of coffee, the other thing I could do is like if you give me a donation of like a certain dollar amount, and I'd have to pick a number, right? So say it's $10, then I could activate TTS and it would just automatically read your comment like with a voice and stuff on screen, which would be kind of cool. So if you donated like $10 through like Streamlabs, then, it would read it out loud, and that'd be cool. So we could set that up, and that'd be cool. Do we want to set that up? We could set up Streamlabs TTS while we're waiting instead of coffee.com, and we could see if that works. Owens just got bounced off stream. I'm not sure exactly what that means, but it doesn't sound good for us. We'll make do. Eddie says, I didn't show your chat. Well, that's okay, Eddie. There you go. Eddie, there's your chat. Hope you're doing great, Eddie. Yeah, man. Well, at least in terms of like the TTS, you can filter it for like, you know, obscene words, and you can filter it for spam and stuff. So, and if it all goes horribly to hell, of course, then I can just deactivate the whole thing. But it might be cool if we got that set up and running. No, Sarah Boone, there's technical problems. At the moment, Trial TV Live is apparently recording it and plans to play it back after the thing is over. And since we don't know how long the hearing is going to be, it could be a while. It could be an hour. It could be an hour till we have something. I don't know. This is live, man. This is what happens when you do it live. And sometimes things happen. There has been a hurricane. I'm not sure if you noticed. There has been a hurricane. Sometimes when you do it live, it's like, the event stopped. And all you have is me vamping for however long it takes to vamp. It's exciting for everybody. I know. It's all very exciting. And that's what we're doing. We're vamping now. Yeah. I know. They're on Zoom, so it's going to go on forever. It could be a hot minute, people. It could be a hot minute. It could be an hour. It could be an hour and a half. I don't know. We'll see how long it takes. But in the meantime, I can bring up your comments and react to them. I can't remember says that'll do me fine with orange heart and tears of face with joy. Thank you. I can't remember. Sarah hasn't unpacked her suitcase yet. I know. Can I take this time to tell law-related stories? What law-related stories would you like to know? There are no real good stories from my time as doing patent stuff. I don't really have good war stories. It's a relatively sedate field of law. My practice area involved computer databases and search engines. So basically what I did was anything involving a database call, which obviously is a lot of stuff. So if somewhere in the background a database call happened, then that was my field. And the more obviously the more core stuff that's related to that. So, and then searches, which of course searches rely on a database, right? Because you're searching against something. So that's what I did. Search engines and databases and search engine calls. And then sometimes you'd get stuff that was using that for other purposes. So some limited augmented reality, because, augmented reality is like you're wearing like glasses or something, and it's projecting on the glass things that augment the reality, right? So you might have like glasses and it has turn-by-turn directions on it that are being displayed as an overlay that you can see on the glass that you're looking through, right? Well, how do you know how to do that, right? How do you know how to display the thing that you have to know where you are, right? And so that's a database call. And so, or a lookup. It's like if you want to have a pop-up that pops up and says, this is France's bakery, 20% off all bakery products. Well, you have to know that you're next to France's bakery in order to have the pop-up happen, right? So some augmented reality, a little bit of virtual reality, because that obviously might involve database calls. Google and people who wanted to be Google, and cell phone lookup databases. And I don't have really good war stories. It's kind of banal. Law school stories? I can tell you a good law school story. I can tell you about founding my own law review in law school. That's a pretty good story. So how I accidentally became editor-in-chief of a law review in law school. That's a pretty good story. How I accidentally became editor-in-chief. It's a pretty good story. Okay. So the story begins like 5 years before I start law school. Okay. I go to University of Akron School of Law. Okay. The University of Akron, like many law schools, has law review. Law reviews are the professional publication for lawyers, right? So it's their journals. And the interesting thing about the professional publications for lawyers is that most of them are published by law schools and published by law students. So it's interesting in that way, right? Because you've like, for doctors, you have like the New England Journal of Medicine, right? For something like that, or Nature, right? So you have these professional publications. But what's interesting about law is, for whatever combination of reasons, most of these professional publications are published and edited by the law students. So it's an interesting little dynamic, right? Because you have the lawyers who are writing professional papers that are being edited, reviewed, and published by the law students, as opposed to like their peers. Anyways, so that's a little bit of an aside. So anyways, University of Akron, like many law schools, has a law review. And in this case, they have two. They've got the main law review, the Akron Law Review, and they've got the Akron Tax Journal, because they do tax law. Okay? And 5 years before I wanted to start, 5 years or so before I wanted to start law school, some law students went to the university and said, or went to the dean and said, "Hey, dean, we'd like to start a law review on international law." And the dean said, "No, you can't do that, but you could start a law review on intellectual property, because Akron Law has a strong intellectual property program. Akron is home to the Inventors Hall of Fame. Okay. It's in Akron. And it also, like, so they have a strong intellectual property law focus. And it's like, we want to be an intellectual property powerhouse. That's what we want to be. Well, the students apparently at the time were not interested in doing this. They were not interested in starting an IP program or an IP journal. So the idea kind of died. So fast forward till I was a 2L becoming a 3L. So I was in my second year of law school, transitioning to becoming into my third year of law school. Okay. This idea, which had been sort of circulating around for a couple of years, got picked up by a graduate student, got picked up by a guy doing his LLM. All right. And he's like, okay, what I would like to do is I'd like to pick up this offer from like 5 years earlier. I'd like to start the Akron Intellectual Property Law Review. Okay. And he's like, fine. So this graduate student, this LLM, recruits some people. And one of the people he recruits is me to do this. I'm like, okay, that sounds really interesting to me. Now, my bona fides were I was an assistant editor at the Akron Law Review. So I was a staff person at Akron Law Review, helping them do the things that the assistants do. And the 2Ls do this like entry level thing, right? And then the 3Ls, some of them become editor in chief or managing editor or whatever, right? They become the senior staff of the law review. That's how that works, right? The juniors, the 2Ls are the line staff, the 3Ls become the editor in chief, managing editor, senior editors, right? Okay, great. So I was a 2L, I was an assistant editor. And so I could have gone like the traditional path and tried to become like editor in chief of the Akron Law Review, but that wasn't going to happen because it just wasn't the right politics. Like anything that has its own internal politics. And I was not going to get voted to be editor in chief or managing editor. It wasn't going to happen. But what I could do was try to like become senior staff over at this new law review. It's like, screw you guys. I'll create my own law review with blackjack and hookers, that kind of vibe, right? Okay. So anyways, the dean of the law school wanted the kids to play nice. They wanted all the children to play nicely, okay? And they already had the law review and they already had the tax journal. The tax journal was under the auspices of the law review. They were independent. Okay, the tax journal was not independent. They were a subgroup of the Akron Law Review. And so they're like, okay, we'd like you to merge in, and we want this to just be another subcategory within the law review. In the same way they have the tax journal as a subcategory, we want you guys to be a subcategory. And it's like, okay. And it's like, so we want you guys to play nice. Now, I'm not sure how they tell the story, but I'll tell you how I tell the story, okay? From my point of view, like, we were willing to do this. We were willing to do this. Where it's like, we will come in and we will work under you guys and we will publish it. But the law review, the upcoming editor-in-chief, the new editor-in-chief, like the girl who is going to be editor-in-chief the subsequent year, right? So she's rising to be editor-in-chief. She's on the same level as me as a 2L. We're both assistant editors. She's been elected to be editor-in-chief for her 3L, right? So she's rising. She and the new managing editor, also like on my same level, who's rising to be managing editor, right? So the new editor-in-chief and the new managing editor don't want to do this. They don't want to do this. And the reason I think they don't want to do it is because they don't know our people, right? The people that are going to be their senior staff are all people who were assistant editors, right? Because that's how that works. The assistant editors become senior staff. The assistant editors become managing editor. The assistant editors become editor-in-chief, okay? The thing is, like, the LLM guy was not an associate editor. He was not an associate editor within Akron Law Review because he's an LLM, right? He's not a 2L, he's an LLM. So he has not been an associate editor, right? And the same problem, like with other people on staff, like they had not been associate editors. I was an associate editor, but the guy who was going to be our editor-in-chief was not an associate editor, right? He just wanted to come in and be editor-in-chief of the IP ledger, or of the IP journal. And basically, they refused to negotiate. They refused to negotiate because we had not gone through this same system. They didn't know our people. They hadn't selected our people. They hadn't chosen our people. We were just declaring ourselves, we want these roles. We want you to just give them to us. We had not been selected through the appropriate process, right? We hadn't been elected. And so they basically wouldn't negotiate with us. All right. So it's the end of my 2L year. And now we're going into the summer between 2L and 3L. And we're trying to negotiate with them, and they just keep turning us down. And basically what happened is that everyone sort of dropped out, right? Because now it becomes a problem of like, well, what are you committing your time to? Because being on law review is a time commitment, but it's a time commitment like something else. You could be doing something else. You could be doing an internship. You could be doing, whatever. And it's like, you're investing time in something that's not going to pan out, or it looks like it's not going to pan out. So quite rationally, people started dropping out. So the person who was going to be editor-in-chief drops out. The person who was going to be managing editor drops out, right? And long story short, I basically became last man standing. I wouldn't let the dream die because it's like I see an opportunity and I'm not going to let it die. So now we are like a month into, or like 2 months into our 3L. Okay, it's like October. Okay, so classes have started. The law review has started. Everyone is doing their own thing. And I'm the last man standing. And so basically I said, okay, I want a meeting with the dean. It's like, I want a meeting with the dean. And I want a meeting with the the deputy dean, the registrar of students, or whatever they're called. So it's like, I want a meeting with the dean. I want a meeting with the registrar of students. So I go to my IP law professor who's been there, forever and has reputation. And I'm like, look, I can get this done. I just need you to back my play. I can get this done. I just need you to back my play. And so he's like, okay, I believe in you. Great. So he gets me a meeting, and now it's my law professor, it's now the head of the IP department at Akron Law. It's the chair of IP law in the meeting. It's the chair of IP law. It's the dean. It's the deputy dean. And it's the editor-in-chief of the Law Review and the managing editor of the Law Review and me. Okay? And now we're sitting in a room. Like the six of us are now sitting in a room. And basically I say to him, in this meeting, I say, look, Dean, you've had this idea for a long time to be the IP Law Review. This is something you want. I have the experience. I was assistant editor last year, just like the editor-in-chief. I was assistant editor last year, and I can get this done. I just need your permission to get it done because they won't let us work with them. They won't let us work with them. And, the editor-in-chief basically said in so many words, yes, we won't let them work with them. They're not our people. They weren't elected. They weren't chosen by us. We will not work with them. And I'm like, Dean, I can get this done. I just need you to give me permission. And he's like, okay. So congratulations, Mr. Mueller. You are now editor-in-chief of the Akron Intellectual Property Law Review. You now personally have my permission to have your own law review, and you can have your own staff, and you can choose who they are, and you can do it, and we will give you the money, and you can publish it. Great. So, with the dean's blessing of I am now the editor-in-chief of my own law review, I then have to now recruit the people to do it. And so I managed to get a staff together, and I think it was 7 people. We got a staff together. And we did publish. We published 2 volumes, which was our goal. We published 2 volumes of a law review, and we got it done, and we got it published, and it was great. And that's the story of how I accidentally became editor-in-chief of my own law review. Basically, I staged a coup, and it was great. And then just for that extra little knife in the stomach of the editor-in-chief of the Law Review, during graduation, when they're announcing your name, they'll say things like summa cum laude or whatever. And for the editor of the Law Review, in addition to saying cum laude or whatever, they introduced her, or were going to introduce her, as editor-in-chief of the Law Review, insert name, right? So that's now a title they're going to now announce at graduation. And I'm like, well, I'm editor-in-chief too. Can you announce me as being editor-in-chief? They're like, we sure can. So during graduation, and my name came first in the alphabet. So I was introduced as editor-in-chief of the Akron Intellectual Property Law Review, Kurt Mueller. And I'm not sure that she knew that was going to happen. And I think she was pissed. So basically, I staged a coup, and I stole her moment of glory, and it was great. End story. And it was pretty awesome. So that is a good story from Law Review. So I totally did that. And give me one moment, and I will show you what we did. Give me just a second, please. Let's see. I think it's here somewhere. Oh, here it is. Yeah. Yeah, that's right, bitch. That's right, bitch. What does that say? What does that say right at the top of the manifest? What does that say right at the top of the manifest? Akron Intellectual Property Journal, Volume 1, Number 1, Editor-in-Chief, Kurt A. Mueller. Fuck yeah. Not that it matters for the purpose of the story, but I chose the color of this. I chose the color too. I chose the color because, you know, the one journal was white and the other journal was blue, and we had to pick a color. You know how it got to be exactly this shade? You know how it got to be exactly this shade? I got a copy of the Pantone color chips, and I looked at the Pantone color chips until I found the one I liked, and I picked this color. I did it unilaterally. It was me. I did it. So this is volume 1, and this is volume 2. Volume 1 and volume 2, and as you can see, they're both reasonably thick. Yeah, fuck yeah. And as I believe the editor of the law review somewhat flamed out, as memory serves. As memory serves, and I'm not sure if this is true, I'd have to double check, but I believe that she went to work for Jones Day, which is one of the largest law firms in the country. I believe she flamed out, she quit law, and then she went to raise chickens. But, you know, that's another story for another day. So, if in an interview they ever ask you, tell us about a difficult time or tell us about a challenge that you succeeded in, boy, do I have a story for you. How much time do you have? Yeah, how much time do you have? The managing editor, though, is now a partner at a law firm, so it worked out well for him. As far as I'm aware, the managing editor wound up as a partner at a law firm, so he stayed in law, but the editor in chief didn't, as far as I know. So hey. So that was a good experience in law school. The other thing was, I think I was the first student at the law school to do both certificate programs, which are kind of like minors, but I guess technically not. But the law school offered a concentration or a minor. They called them certificates, but they offered one in litigation and they offered one in intellectual property. And I think I might have been the first one to do both because I'm just that much a masochist. And just for like, to show you how much of a masochist like I truly am, like between that 2L, between the end of my 2L and the beginning of my 3L, I was assistant editor of the Akron I was assistant editor of the Akron Law Review. I was trying to form the team that would become the Akron Intellectual Property Journal as editor-in-chief. I was doing moot court. I did mock trial, and I did 2 different moot courts at the same time, plus my classes. So I was a bit of a masochist, and I was like, how much stuff can I do all at the same time? Also, technically, I was part of the clinic, although I never did hours because I didn't have time. But I got my license to practice as a 3L within the clinic. So technically. As far as I know, they're still doing it. Yeah. As far as I know, they're still doing it. I think after the second year, I think it was still independent. And I think the third year, they then wound up merging into regular law review. So I think they're still running, and I think it's independent, or I think it's dependent now. It's within the law review auspices. But, you know, hey, we ran it independently. I ran my own damn shop. And so that was cool. And yeah. So that was an awesome experience from law school. And then I wound up graduating like with a 3.4 GPA, which was like top 40%, or maybe it was a little better. It was definitely in the top half. But I didn't blow it out of the water, but I did fine. I graduated with like 3.4 something GPA. I did fine. I'm still a little bit salty about not doing very well in contracts too. I think I got a D, and I'm still salty about it. Oh, and then there's the time I argued with my ethics professor over my grade, and I was right. And I had to argue with him a while, and I finally got like a bump up I got like up a bump. So I think I got like from a C+ to like a B- or something like that. I got it moved up like one. I got my grade moved up one step because I was right. I know I'm right, and I'm still right. And I still remember the damn question. I was like, I argued with him for about like 40 minutes on the damn exam until he finally like gave up and just gave me like the grade. I'm not sure if I convinced him or if he was just tired of arguing, but either way, I got it. But I deserved it. I deserved it. So I'll tell you about the problem. And this is something I've described before. I'll tell you about the problem, okay? So this is an ethics problem, okay? So the hypothetical would be something like this, okay? Let's suppose that a client comes to you and asks you to do a job for them. And you say to them, okay, I think that this job is going to cost $10,000. So I want you to give me $10,000 that I'm going to charge against, as a retainer. Not a classic retainer. A classic retainer would be I get the money no matter what I do. This is a I get the money, but you have to give it to me up front, right? You give me the money up front and then I charge against it, okay? So you're like, okay, this job is going to cost $10,000. Give me $10,000. I'm going to charge against the account. Great. So the client gives you $10,000. And somewhere along the line, you figure out like this job can't be done. You can't do it the way the client wants to do it. It can't be done. It's just not working. And so you go to the client and say, look, I just can't get this done for you. But I have put in, $3,000 worth of time. Okay. So I've put in $3,000 worth of time. So I'm going to return this. So that's what it is. The client says, no, you're a really bad lawyer. You didn't do what I wanted you to do. So I think you only deserve $1,000. I'm only going to let you have $1,000. All right. So it's like, okay, so what do you do? What do you do? Now my attorney said, or what can you do? Like, what are the limits here? Like, what can you do? Now I think the ethics professor said, well, like it's all in dispute. And so you have to like freeze it. And I'm like, no, that's not right. You don't have to freeze it because it's not all in dispute. Only $2,000 is in dispute, right? It's like you only have to you have to return the money, or you can't keep money in the account that's not in dispute, right? You have to get the money out of the account once it's not in dispute. You can't keep client money in the trust account. Once it's earned, you have to get it out of the account. You can't just keep it there. So, but it's like, look, not all the money's in dispute. So here's what you do, right? We both agree that the client should get $7,000, right? Because I say I earned $3,000. He says I only earned $1,000. But we both agree I didn't earn the $7,000, right? We both agree. So I need to return the money. It's not my money, it's his money. So I need to write him a check for $7,000. The other thing is we both agree that I'm entitled to $1,000, right? I say I'm entitled to $3,000. He says I'm entitled to $1,000. Well, we both agree I'm entitled to $1,000, right? We both agree I'm entitled to $1,000. So I write myself a check to my personal account for $1,000, right? And then the $2,000 that's in dispute, because that's the only amount that's in dispute, we'll go argue about that for a while. However, we're going to go argue about that, right? We're going to go sue each other or whatever it is we're going to do to figure out who owns that money. right? But that's the only amount that's in dispute. So I'm like, okay, I write him a check for 7,000. I write myself a check for 1,000, and $2,000 will go argue over for a while. That's the right answer. But whatever the answer was on the test was not that. It was like, oh, all $10,000 is in dispute. You have to like keep it all in trust. I'm like, not only do I not have to do that, I ethically can't do that. I can't freeze it all. Or it's like, oh, you have to return it all. I'm like, no, I don't have to return it all. I don't have to do that either. I only have to like hold in dispute the amount that's in dispute, which is only $2,000. So I argued with him for like 40 minutes to convince him this was the correct answer, which it obviously is. And eventually I won. Eventually I won. Or he gave up. One of the two. So that's another one from law school. Yeah, I totally was right. I was 100% correct. So then my law professor was this interesting guy. He was Jewish, and he dressed up at least as like a sort of like an Orthodox rabbi. He had like, you know, the curls like in his hair and the hat and like the whole thing. And he was my contracts professor. And you know, he would say, as many law professors would say, you know, what is consideration? And many law professors would say a consideration is a peppercorn. Right? Consideration is anything of value that you didn't have to give before. A peppercorn will be fine. Like the idea of a peppercorn being consideration is not a revolutionary concept. What is perhaps a little bit more revolutionary is quite frequently in class, he would literally throw peppercorns at us. I guess it got the lesson through. So there was that. And then, of course, another memory that I had was my torts professor, who was also my IP professor, who was also the chair of the department, was an interesting and somewhat ornery guy. He's a little old school, like kind of like Paper Chase. For anyone who's ever watched the movie Paper Chase, he had some definite Paper Chase vibes about him, and sort of like the way he liked to do things. He's a very sort of ornery guy. And as is traditional in law school, the entire grade is the final exam. So as is traditional in law school, 100% of the grade is the final exam. What was interesting for him is that his final exam was one question. It was one question. It took me, I think, an hour to read the question, because, you know, the question went on for like 8 pages, but it was one question. I got an A. I felt good about it. Another one was good, was Civ Pro. My Civ Pro professor, like she said one time in Civ Pro, she did not put Erie on the exam. Erie is a very famous case. Erie stands for the proposition that a federal court standing in diversity jurisdiction, when they're deciding state law relevant issues, they apply federal procedure but state substantive law, right? So if there's diversity jurisdiction, which means we're doing state law, then we do federal procedure, but we do state substance, right? This is Erie. It's a foundational case of Civ Pro. Everyone knows this, right? But she said, like in one of the prep sessions, that one time she didn't put Erie on the exam. So when it got to exam day, I did it and I couldn't find the Erie question. I couldn't find the Erie question on the exam. So I did the whole exam and I'm like, but I didn't discuss Erie anywhere. And so, like, you know, I was kind of freaking out about it for a while. And, you know, after like, and I still had time left, you know, in the exam, you know, at whatever. So like at one point I got up and I went to her, you know, during the exam. And I'm like, I know you can't answer this question, but I'm going to ask it anyway. Is there an Erie question on the exam? And she says, I can't tell you. I'm like, oh, okay. And then I went sat back down. And I guessed. But I guessed wrong. I think the class was like half and half. We were split. She did a good job of hiding the ball on that one, and so of the students who tried to find it, half of us guessed wrong about where the problem even was. Half of us couldn't even figure out where the problem was, and we guessed the wrong place. So I guess I guessed wrong on that one. So that was funny. It was also interesting because apparently, although this was not known to me at the time, when I was studying for the Texas bar and I was doing my sort of flash questions, apparently Erie is the one I have the hardest time with on the bar exam. So I wouldn't think it would be that hard, but apparently the actual practical of it, Erie is the one I struggled the most with. So I guess it was a weak area of law for me then, and it still is now. Who knew? But apparently spotting the Erie issue is not my strong suit. Who knew? Are these enough law students for you? You're exporting the video now. It's 28 minutes, but most of it is crap. Good. I look forward to this bullshit. Thank you for keeping me posted. Thank you for keeping me posted on this issue. Yeah. So there's some fond memories of law school. I miss law school. Is there homework in law school? No, not really. Everything is the final exam. I think I had one class that technically put like 10% on the midterm. But strictly speaking, no, there's not homework. Also, law school's funny because it's more like high school than college. You have lockers again, and you basically have periods again. And it's kind of like the drama of high school. So law school is more like high school than it is like college, which is pretty hilarious. You have drama and you have cliques and you have like lockers and you have periods, and it's an interesting thing, man. It's an interesting thing. You have to do your own homework, basically. You have to like, prep the case yourself. Have you ever thought about teaching law school? Sure, I'd love to teach law school. I wouldn't even know how to go about applying to do that, though. I wouldn't know how to go about applying to be a law professor. I don't know how one would do that. But if you are a law professor, and you're aware of any openings and you know how to actually like apply to be a law professor and you'd like to help me out, if you'd like to guide me in this effort, please feel free to contact me at curtin.uncivillaw.llc.com, and I'll be happy to try to apply to be a law professor. I'm pretty good at con law. I've got that recognition down. For 1L subjects, property law would probably be like, I can do property law and I can do torts pretty well. Contract law apparently is not my strong suit. Who knew? Yeah. So probably torts for 1L or property would be fine. Con law for the 2Ls. Community college? There's not a lot of law schools at community college, so I'm not sure that really works. I don't particularly want to teach patent. I don't particularly want to teach IP law. Or I don't want to teach patent law, at least. I don't really want to teach it. I've lost whatever love I have for it. I mean, wouldn't be my first choice, really. I don't really want to teach. I'm not sure I really want to teach patent law. I teach trademark or copyright, but I don't know. It's not that interesting to me. There's nothing left for me to learn, and that's not fun. I still want to learn things. And so it's like, if I'm not learning, I'm not having fun. So, with con law, there's always new things to learn because, there's always new cases. So, you get to learn as the students are learning. It's like you're all learning together. It's fun. But yeah. What's the image on my shirt? It is is the shape of South Carolina, along with the South Carolina flag. That's the shape of South Carolina. And that's a palmetto tree, and that's the moon, which is the symbol on the flag. Is the Boone hearing display delayed? Yes. Does trademark on cars expire after 95 years? Trademark expires after 10 years, but can be renewed indefinitely. If you're thinking copyright, there's no copyright in cars. If you're thinking patent, they expire after 20 years. So hopefully that helps. As a VP at a university, you only need to be a licensed attorney to teach law. That's correct. Yeah, I don't know. I don't believe any of my law professors had any advanced degree beyond a JD. The ABA issued an opinion back in like the 70s where they think that a JD is equivalent to a PhD. Now, I wouldn't necessarily recommend telling that to a PhD, but technically, they say it's the same. And, strictly speaking, I mean, of course, I could teach undergrad, although it'd be weird. It would be strange because I don't have a PhD, but there might be some JDs out there that are teaching undergrad. It would just be weird because I'd be properly referred to as Mr. instead of Doctor. So that'd be a little bit different. Instead of being Doctor, technically it's Mr. But that's okay. I don't need to be Doctor. I could teach political science. I'd be reasonably good at it. I mean, surgeons in the UK get called Mr. So, that's fine. And they actually do surgery. And they're properly addressed as Mr. So it's not so bad. I can be Mr. It's fine. This is what happens when your profession started as a barber. This is what happens when your profession is an offshoot of being a barber. The surgeons are just barbers that, decided to stop giving haircuts. So they get called Mr. Yeah. But if you're a VP at a college, and you'd like me to teach at your college, please contact me at Kurt at Uncivil Law, LLC. I'm available. I can teach political science and law. I'm okay at it. I'll be fine. This is funny, by the way. Because Ian the other day was commenting on the fact that apparently in Canada, if you call yourself Esquire, that's considered like a really pompous, douchey thing to do. That does not have the same problem in the US. Like, I've used ESQ on my name. I've done it before. And it's not like, yeah. I mean, it's a bit more like culturally sporadic, but I'd have no problem putting ESQ at the end of my name. I wouldn't feel embarrassed by it, right? Apparently in Canada, that's a big faux pas. The equivalent faux pas in the US is if you find a lawyer who wants you to call them doctor. That's the equivalent faux pas. If you find a lawyer who insists you call them doctor, run. run hard. That is a big faux pas in the legal community. We do not do that. We do not do that. I'd have to move to New Mexico. Hey man, it's the land of enchantment. I can do New Mexico. It's both Mexico and new, and it's a state and everything. So I can move to New Mexico. It's fine. Yeah, I'll just have him call me professor. That's fine. I'll just have him call me professor. I'll be fine. Well, and I create my own college for community college, my own course, and maybe someday. I'd run to Cary. Oh, that'd be fine. I'd be like, students, here's how not to be a prosecutor. Let let us go. Let's talk about how not to be a prosecutor. Let's talk about how one of your goals of being a prosecutor is to seek justice, not just convictions. Here's an exemplar of what not to do. Don't do this. $180,000 pay per year sounds pretty good to me. $180K per year sounds pretty good to me. In Brazil, all lawyers are doctor. Oh, there you go. See, different cultures, man. Different cultures. I can't speak about the finer points of the Brazilian legal system on any level, to be honest. Particularly because it's not even common law derivative. It's not a British law derived. At least with the British law derived, I can cheat if I have to, because there's just enough commonality that I can at least try to understand what's going on in a common law country. But Brazil isn't common law, so it's not British. So I don't know what the fuck's going on in Brazilian law. I don't have the first clue. Does Brazil have laws? I don't know. I don't know if they have laws or what they do. I don't know. Maybe they have Thunderdome. I don't know what they do in Brazil. I got nothing. Brazilian women are nice to look at. Women from many countries are nice to look at. There are women from every country that are nice to look at. We're on a different channel the other day with the lawyer chick. I'm not sure if I was on it. I don't think I was on with her. I was just in her chat. I don't think we've been on stream together in a while, but she's cool. Yeah, but if you'd like to pay me $180,000 and be a professor in New Mexico, we can definitely talk. I still do classes online and stuff. It'd be great. I think I'd be pretty good as a professor. I don't know if I necessarily be the best professor. I'm not sure if I can achieve that lauded goal, but I think I'd be pretty solid as a professor. I've got lots of experience talking to a lot of idiots about law. I'm sorry, I couldn't resist. I'm sorry. Yeah. I'm enjoying hanging with you guys. This is fun. even if we spend time trying to wait for a hearing that may or may not ever come. Maybe the hearing won't ever happen. It's live TV, baby. We'll do it live. Did you say how long the delay is? Not really. They said they were uploading it and that is shit. But we'll deal with that when we get there. I'm in a good mood today. I'm in a good mood today. It's nice when it's a good mood. I feel pretty, oh so pretty. I feel pretty and witty and gay, and never have a pretty meal today. I feel charming, oh so charming. And I'm also possibly partially insane, which also means I'm an outstanding professor. Right? I mean, I may have just a little touch of the crazy, which makes me a perfect shoo-in for any faculty anywhere. It's too funny. Are we going live? I heard rumors. Another 5 minutes? All right. Yeah, it's that maybe the charitable way of reframing that is they say that there's that borderline between genius and insanity. And so at the risk of calling myself a genius, maybe I'm just straddling that line. Hopefully on the right side of it, more than not. But maybe it's you can't have one without the other. Who knows? Welcome to Law 101, Class 1. Have you considered not breaking the law? That would be helpful. Have you thought about, just not like being a complete asshole? If you're not an asshole, you probably will be fine. You're a genius, Kurt. You're a genius. Are there continuum classes need to practice a specific kind of law? Not exactly, no, but there are continuing legal education courses, and every continuing legal education course makes me want to die. They're all, I don't know what it is. I don't understand what it is. Every single continuing legal education course I've ever been in is horrible. They're all mind-numbingly, they make you want to cause harm to yourself bad. Every time I have even the slightest doubt about myself as a lawyer or as a professor or as a YouTuber, all I have to do is remind myself that continuing legal education exists. They're all universally atrocious. They are so safe to the point of like absolute banality. Like when you've watched something like a corporate, like any corporate training, like ever, okay, and they've been so incredibly processed and they're so incredibly safe, they make you want to die. All possible life has been completely squeezed out of them. All possible interest or offense has been absolutely wrung out of them to the point that what is left is so safe and so banal and so boring, it makes you consider causing harm to yourself. That's every continuing legal education. It has been sanitized to absolute nothingness. There's no life left in it anymore. It makes you want to die. So every time I ever doubt myself as a teacher of law, I just remind myself continuing legal education exists, and I feel much better. We're going? We're starting? Ah! Hey! It started! Yay! It started! Woo! There's things happening now on the other screen. All right, let's tune into this shit show. This should be good. Yeah, Lord, help us all. Help. Like, all right, hold on. Let me readjust the margins. All right, kids. Let's see what we got. Strap in. I promise no quality of any kind. Oh, Lord. Here we go. If this is bad, I'm blaming you, Trial TV Live. I'm blaming you. Oh, good. Oh, yeah. Oh, yeah. Oh, we're in for a good time. I can tell already. Why can I not hear anything? Oh, dear. Is this a hearing test? Is this a hearing test to try to determine whether or not I'm too old or not? I can hear the high frequency noise. So if this is a hearing test, I can hear it. Moving on. Um, uh, just wait for the echo. Great. I promise my lectures will be better than this. Yeah. Okay. I'd like again to take note here as we're trying to pin blame. I would direct your attention to the very prominent Trial TV Live logo. I'd like to take note that Trial TV is apparently proud of this and has branded their video to make sure that you're aware. This video comes courtesy of Trial TV Live. They apparently stand behind this to the point they are willing to put their imprimatur on it, a seal of quality on it. They stand behind this program. Outstanding. Much like Good Housekeeping, ... Good Housekeeping is a good brand of certification when it comes to household goods. And much like that, Trial TV Live, nothing but the best. Woo! But Mom, I want to get Trial. Son, we have Trial at home. Trial at home.
Do y'all hear me now?
Yes, I do. Thank God. I still need to put some sort of high pass filter on this or something. I don't know. Let me try running this audio through voice mod. I don't know if this is going to work, but we're going to give it a shot. Let's see if I can clean this up at all, because it is killing me. Hold on. All right, let's see if we can clean this up at all.
Can't hear the judge. I think it's on y'all's end. We cannot hear the judge.
But we hear other things.
Oh, I uninstalled the thing. I can't do that. That's right. Oh, never mind.
All right,
Oh well.
Want me to hold on this end?
Counselor, can you hear me?
Yes, I can.
Technically, I can hear you.
To start over and pick up, or rather than pick up where you left off, start over on the issue of, we were discussing the depositions of the recently identified experts. We had confirmed that Dr. Harper's deposition was October the 1st. Dr. Birkeland, my understanding, is no longer being called as an expert to testify, but is only being offered in some kind of advisory capacity. And all efforts to depose Dr. Brannon have not borne fruit yet. You can pick up where you've left off.
Yes, we have tried to get that coordinated and have had no success with opposing counsel. I am not even sure what this person will testify about. I don't know if it's another battered spouse syndrome expert. Florida law seems pretty clear that any other mental issues would have to be insanity. So I'm not sure exactly who this doctor is. We had prayed the court for relief and at least getting a report by today from him. We have not gotten such a report. So I don't know when we will be able to coordinate that deposition prior to trial.
Okay. Mr. Owens, with regard to Dr. Birkeland, is Mr. J's position that that person is not going to be called at trial accurate?
That's correct.
Okay, all right. So is there any reason to worry about deposing that person at this time, Mr. J?
No, sir.
Okay. With regard to Dr. Brannon, are you still going to be offering him as a witness at trial, Mr. Owens?
Yes, Judge, and
I assume that this is hurricane related, and apparently the great state of Florida has been reduced to tin can and string technology. So, okay.
I'm going to be down there Monday night, and I'll be available all next week. I can do it at any time. The only two things I've got is the Dr. Harper's deposition on October 1 and the state's expert evaluating the defendant Sarah Boone on Wednesday, October 2nd. But I'm free anytime, and we can make Dr. Brannon available any day that week. I would assume we just have to get with him.
Mr. J?
It would be helpful if I had a report so that I could craft a preparation for this person's deposition.
What is the basis to require the production of a report?
Under 3220F, you and your discretion could order it to speed these proceedings along so that I do not have to engage in a fishing expedition for an inordinate amount of time on the eve of a trial that is
what I could do
on October 7th.
What I could do that would actually be, is it possible to get like the raw version of this Trial TV Live? Can you send me a link to this file? Because what I could do is I could run this through Adobe Podcast and it would make it not suck balls. Can I get the original file that you guys saved, or is that not going to happen? Because I'm willing to do it for my chat. Let me know. How you did that? You ran it through Adobe Podcast? You did, and this is what you got? You ran this through Adobe, and this is what came out? Shit. All right, never mind.
When I am unavailable on Friday next week due to an insanity placement hearing in Osceola County that has been previously scheduled and rescheduled numerous times, I am not opposed to working on Thursday, but Thursday is a court holiday, so we would have to make arrangements. And then Wednesday,
If there are other persons in the media who are appearing virtually to observe this proceeding, I need you to mute yourself, please. There's an individual by the name of Lou. Sir, I need you to mute yourself in order for the court to conduct its business.
You have no idea how awful it was. That's a good comment, Trial TV. I like that you have no idea how bad it was. Oh man, when this is the enhanced version, oh my god, that's funny. It's too funny, man. Yeah, no, that's a good comment, man. I like that. Yeah. Good one. Shit. All right, we press on, we ride.
Whoever is participating in the hearing this afternoon, whose name is Lou, if you can hear me, this is Judge Kranek. I need you to mute yourself, please. Mr. Owens, how are we going to be able to coordinate this step? Well, let me go back to you, Mr. J. 3.220F says, on a showing of materiality, the court may require such other discovery to the parties as justice may require. And is that your position that allows me to provide written reports?
Yes, it is within the court's discretion to order an expert who has not produced a written report, nor have I gotten his CV, to produce a report in efforts to coordinate discovery with opposing party.
Mr. Owens, what's your response?
Judge, my response is it's a narrow issue, battered spouse. Dr. Brannon is an expert. You know, I've mentioned him 2 or 3 times. He testified in the Marsha Thompson case in Palm Beach County. That's his field of expertise. It's not going to be a fishing expedition in his deposition. It's going to be related to that sole issue, battered spouse. And I'm available Thursday. I realize that's a holiday, but I'm available as well. I can make him available. I'll do everything I can to set the deposition as soon as possible.
Do we know of Dr. Brannon's availability?
I can try to get him on the phone now, Judge, if you'd like me to.
Any objection to doing that?
Dr. Brannon's phone number.
I don't want to burden the court. Judge,
Mr. Owens.
I have a pool camera in here. There is no need for anybody else to be on the line except for Mr. Owens.
I can't control that. The media reached out to court admin today and said they were going to be hearing virtually. I'm trying to log in to my app to silence this other person.
I'm having difficulty.
I'm with you on the difficulty scale.
We still haven't figured out how to prevent people from joining who aren't supposed to be on the line technology. Oh, Lord.
And I sympathize with it, but I don't have the ability to remove him at this time. I'm working on it right now.
If he is available on Thursday, then that will be our preference, because it's my preference to do it in person.
Fine. That will be an in-person deposition no later than Thursday of next week, the 3rd. If you are unable to have that deposition coordinated, you need to let my office know immediately, and we will set a hearing as necessary. I'm in trial next week, but I will make the time in order to make that happen.
He is living or working as listed on the witness list in South Florida. So under the rules, the deposition should have to occur there, unless Mr. Owens is requesting a different location.
Mr. Owens, are you requesting a different location other than South Florida? Where's the location of Dr. Brannon?
Well, we'll ask Dr. Brannon, but if he's willing to come up here for the deposition, I'm fine with that. Or we can travel, whatever. Or we can do it by phone or Zoom. I'm available, like I said, all week next week. I'll do whatever is necessary to get the case resolved.
It's going to be an in-person deposition, so the issue is simply location, whether it's in South Florida where his office is or here.
Doesn't matter to me.
Okay, then you've got your deadline by next week, Thursday, to take that deposition. I have reviewed the state's responses to multiple matters, including the amended exhibit list and the second amended exhibit list, and a response that the state had filed regarding a second motion. Was there a second motion to suppress that was filed?
Judge, they filed a notice of objections to the state's evidence late last night. Contained within that objection to the state's evidence was basically an unfiled, legally insufficient motion to suppress statements based on a statement made to a patrol deputy prior to the first statement to the detectives in an unmarked patrol car on February 24th, 2020.
Okay. I have not seen when that hasn't cleared the court file yet, I don't believe.
Judge, I believe I sent it directly to your JA. Defendant's objections to plaintiff's exhibit list. Would have been sent to Ms. Barrios.
I have. Mr. Owens, the second paragraph of the second page of the objections seemingly refers to a different interrogation than what is made reference to in your motion to suppress of September 24th.
That's correct.
Okay.
May I be heard?
You filed your objections. As of right now, there's only one pending motion to suppress. Is there
That's
another
cool.
motion to suppress that's going to be filed?
I'm not sure, Judge. I had some time constraints on filing this defendant's objections to plaintiff's exhibit list. I put those last two paragraphs in page 2 on there for the purpose of preserving that issue because my client asked me to. Whether or not I'm going to file those or not is an issue that will be decided on Monday when I drive down to speak with her. I may or may not file those, but I wanted to preserve that potential issue, object.
Why are their lips moving but no audio? You couldn't have put in a filter for this like high pass stuff or something?
Mr. Owens, can you hear us? Cannot hear you, sir.
Oh, now we've rearranged the visuals.
Can you hear me now?
Yes, sir, we can.
I'm sorry. That was my error.
What if any response do you have to? My concern is I don't have a complete picture of what is attempting to be filed, and you're telling me you're not going to be able to know until you meet with your client on Monday as to whether or not you're going to file a motion to suppress. We're rapidly proceeding to trial in this matter.
I understand that, Judge. I had a deadline for filing these defendant's objections to plaintiff's exhibit list. Based on my last discussions with Ms. Boone, she expressed concern about those two statements that are on the second page, the last two paragraphs. I simply was preserving the right to make an objection on the two exhibits, which is the body cam of Deputy Rodriguez and the audio tape that was taken, the interrogation that was taken in the squad car by the two homicide detectives.
If I understand what he's trying to do, he can't do what he's trying to do. If I understand it, and I may not understand it because it's hard to understand because literally it's hard to listen to. But it sounds like he's trying to string together motions, and you can't do that. So it sounds like he has a deadline to file something. And so he's like, well, I don't know whether or not I'm going to. So I'm going to file something that preserves my intent to file at a later time. So it's like, I have to file by this date. So I was like, well, I'm going to file a preservation that allows me to file at a later date. It's like, you can't do that, man. It's like, if you have a deadline, you have a deadline. And I've known attorneys to do this. He would not be the first attorney to do it. Other attorneys have tried to do it. Other attorneys have tried to do this string thing. It's like, oh, okay, well, I'm going to extend the deadline by filing something saying I'm going to file at a later time, and then I'm going to try to backdate it back to my notice, basically. I've known attorneys try to do this. Most of the time, the courts will like kick them in the teeth for trying, but that's what it sounds like he's trying to do. It sounds like he's trying to extend out his clock. And if I were the judge, I'd tell him to go to hell. Get lost. No, you can't do that.
I don't know whether I'm going to even file a motion to suppress on those 2 paragraphs on the second page. I plan on driving down Monday. I will see her Monday night. We'll make a decision at that time.
As the judge, I'd be like, no.
I had to preserve that issue in this objection.
As the judge, right about now, I'd be like, let me help you out with that. Your decision is no.
Of these exhibits.
Right? Yeah, we can't do that. Because we can't get into a private Zoom meeting, and you're not going to let us into the Zoom. I don't know. Because there was somebody that said they had a Zoom.
He'd be better off arguing the hurricane, to be honest. Like, because it sounds like he's trying to string it together. He'd be better off arguing manifest necessity due to act of God. I needed time. I couldn't put it together because hurricane. That'd be a much better argument.
I don't know who that is.
Can't we just do the old-fashioned way? Counsel can call by phone.
Can we pull him in to, can he call over the overhead? Yeah. All right, Mr. Owens, we're going to give you...
Yeah, and then also, like, as a technical legal matter, he doesn't need to, strictly speaking, confer with his client. Because strictly speaking, it's his decision. The client's decisions in a criminal matter are fairly narrow. The client gets the decision whether to plead guilty or not, whether to have a jury trial or not, whether to appeal or not, whether to take the stand or not, and that's about it, right? Everything else, the attorney gets the decision. So whether or not to file the motion to suppress, he doesn't need the client's permission. He can just do it. And he doesn't need the client's permission to not file it. He can just do it because he's the attorney. So I was like, I need to talk to my client. Strictly speaking, no, you don't. You don't even need to do that.
Number to call in, sir, because there are so many people that are trying to participate virtually.
Okay.
The clerk is going to call you right now, sir.
Okay.
Let me pull up this new one. Because I can wear makeup.
Can I be on video but turn off video?
Yes, it is. Okay, so remember when we got the other day after that last hearing, he was like, we wasn't good enough on Friday.
Yeah. And if he's not sure whether to file it, then why not file it? Because you can always take it back later, right? You can always withdraw the motion. So if you're not sure whether or not to do it, then why not do it and then change your mind later? This you can, because you can change your mind one way, right? You can change your mind the other way around. So that would be better technically too. If you're not sure, just file it. And then be like, oh, you know, on second thought, no. Unfile it. That'd be easier. Also, you're not going to win the motion anyway, by the way. You're not going to win. As long as we're at it, you're not going to win. But, you know, you can try. I'm sorry your client said stupid shit. But, you know.
The defendant decides taking the fact, but not liking particular fact or fact is an issue. The reason for suppression in the form of rules of criminal procedure is any performance-like expression that violated the United States Constitution. This no difference getting a search individually or improperly and unlawfully. State versus Tiffany. By the way, y'all can find out the way this is written. This is coming from Prosecutor J. He's sort of like, let me talk. He's gonna get a little bit of this.
I do appreciate his look, though. I'll give him that much. Although his office is really not doing himself any favors. He's got himself a whiteboard, which I like. I like the whiteboard, you know, for like sketching out things and stuff like that. And he's got like, you know, pads next to it for writing things, and like basically I'm assuming they're like Post-it notes, like big Post-it notes that he can like take off and post. So I like that he's got that set up in his office. And he's got one piece of art on the wall, but it's kind of crooked. And then a whole lot of white nothing. It's a little plain. Also, I don't really care for the floor on his office with his tile look. It looks like the tile in a bathroom, to be honest. I'm not really digging it. I'm not really sure what the milk crate looking thing is doing over next to the air freshener on the right. I'm not really sure what that's doing over there, but okay. And his desk could be a little bit better organized. Also, what is that thing that's plugged into the wall behind him that looks like it could be some sort of motion detector or something? What the hell is that thing that's plugged into the wall? Anyone want to take any guesses as to what that is? No, it's not an air freshener. The air freshener is over on the right-hand side. Unless he's got two of them. What's all the sounds for? I don't know. Well, we've got more mouth moving and no audio, so I'll just have to provide audio. Your Honor, I'd like to file a motion that my client is a moron and really didn't understand what's going on. She couldn't have provided an intelligent waiver because she's so stupid, as is confirmed by the multiple letters to the court, that she couldn't have possibly knowingly understood her rights. And so the motion to suppress should be granted on the basis my client is a dum-dum. Your Honor, I'm the state of Florida, and I have to object to counsel's suggestion that a motion should be suppressed on the basis that the client is a dum-dum. If client was a dum-dum was a valid legal motion, Your Honor, the state of Florida wouldn't be able to prosecute anybody. I hope this little vignette has been satisfactory for you. All that improv classes is good at something, man. I mean, it looks like that this black thing on the wall behind him looks like it's got some sort of lens that's maybe giving off IR light that's being picked up by the camera. Is it a motion detector? Is it a camera? If I stare into the void, does the void wind up staring back at me? We got to get this guy some art for his walls or something, or some wallpaper or something. The plain white walls are not really working for me. And he looks like he's got overhead fluorescent lighting, and that's just sad. They said no more audio, judge cuts it off. Apparently. Well, I'll just have to entertain you with more dialogue, more vamping. I will not allow the lack of court audio to in any way stop this stream. If you think that the lack of court audio is going to be a problem for Uncivil, think again. I'll just comment about more things that I see in the room. We've got this blue glass back there with some sort of dark liquid in it. We can take reasonable guess as to what dark liquid is in the glass. The desk, I don't know, it just seems like a little to me. The crooked picture is definitely a thing. Can we get this guy some art? Can we? I'll give this guy maybe a Norman Rockwell or something he could put on his wall. I don't know. I've got a picture of Starry Night I could send to him that I picked up at like the dollar store. I could send to him and he could frame that. Lil Van Gogh in his life never hurt anybody. Okay, and apparently no one is sending us video.
I mean, it just cut off.
Damn you, Trial TV Live! Well, that's the end of the hearing. We have learned nothing of value whatsoever. We have learned nothing of value except he apparently is trying to do a string motion, I guess. It sounds suspiciously like he's trying to do a string motion. It sounds like his deadline has run and he's trying to string it together and do a string motion. Which, if I were the judge, I would tell him to go to hell. But apparently this judge didn't say go to hell because, well, it would have been a much different hearing. So I don't know if the judge is considering allowing the string motion, which the judge really should not do because that just invites more string motions. And you really shouldn't do that. You think it's a Ring camera? Why does the guy have a Ring camera just in his office, though? If you're right and it's a Ring camera, why does he just have a Ring camera plugged into the wall of his office? What's that about? What is with the Ring camera just plugged into his wall in his office? What is he trying to do with it? You know? You think it's a doorbell? Maybe it's a doorbell. Court TV has better video. Court TV can't possibly have better video. That is an impossibility. Court TV can't possibly have better video because Trial TV Live is the source of the best video and audio in trial land. So surely Trial TV Live must have the best audio and video. Apparently they've lost power in the internet though at their place. Fine. Let's see. Who I can't find another feed. No one has a feed. Court TV doesn't have a feed. Court TV is feeding it? Are they?
Coming soon to Court TV.
I don't see it. It's up on the Court TV website. It's not up on their YouTube page. It's up on their website. Oh, okay. They want to be all fancy, but with time running out, chaotic Sarah Boone hearing grinds to a halt. Epic. Is this from today? September 27th. It looks like it's from today. Oh, they have a totally different camera and setup. They're like professionals over there. We can watch the hearing again. We can watch the hearing again. Okay, it's hearing part 2, everybody. It's hearing part 2. Maybe we'll learn something of value. Trial TV Live has failed us. They were the chosen one. They were the chosen one. They failed us. No. No. All right. Let's try this again.
William J. for the state.
There's been some activity over the last couple of days.
Audio for them? Do they have
in
audio?
The court file and correspondence between Mr. Owens' office, my office, and the state attorney's office in attempting to coordinate some hearings.
Why do I not have audio?
The first item on the court.
Why do I not have audio? You guys have audio. I just can't hear anything. You hear it. I just can't hear it. There we go. There we go. Okay.
William J. for the state.
Mr. Owens, you are muted, sir. Judge, can you?
Okay. I'd like credit right now. I'd like credit right now because I have capped the audio from like court feeds to -15, so that no matter how shitty it is and no matter how much they attempt to blow out your ears, they can't succeed. And they just tried to blow out your ears right now. So I'd like to take credit. I'd like credit because I thought ahead enough to put in a limiter so it wouldn't play higher than -15, so that when it tries to blow out your ears, it won't blow out your ears. And I want that to be recognized.
Loud and clear, sir. Can I get your appearance for the record?
Yes, I'm James Owens, and I'm here representing Sarah Boone. I'm the lead on the only counsel that's going to be here today representing Sarah Boone.
All right, very good. Ms. Boone is in the jury box. Ma'am, if you could please raise your right hand. Madam Clerk's going to go ahead and swear you in. Ma'am, good afternoon. Could you state your full name and date of birth for the record for me? All right, we are here on trial case management in this case. I know there's been some activity over the last couple of days in the court file and correspondence between Mr. Owens' office, my office, and the state attorney's office in attempting to coordinate some hearings. The first item on the court's list is whether or not the examination of the defendant took place as ordered in the court's September 20th order.
No, Your Honor, there's no time.
Okay, when do we believe we're going to have the opportunity to have that examination by the expert of the state's choosing?
Wednesday, October 2nd at noon.
Okay, and has that been cleared with everyone's calendars?
Yes, sir.
Mr. James?
There is closed captioning. Unbelievable.
Mr. Owens, is that accurate, sir?
That is, Judge, I can't see my client. I don't know if that is an issue or not.
Give me a minute, sir.
There's some closed captioning.
There you go, sir. He's on the far right-hand side of the box.
I see you, Judge.
Okay, very good. All right, so that examination is taking place on October 2nd at 12 noon. The next item that I have on my list is depositions of the recently appointed experts for the defense. I know Dr. Harper's deposition is set to take place on October 1. With regard to Drs. Brennan and Birkland, are those depositions in the process of being scheduled, or what's the status on those? Okay.
I I was told by the defense that they're not calling Dr. Birkeland. He was only going to be a consultant, so there will not be a deposition of that doctor. The other doctor, we have made attempts to try and coordinate and not gotten anywhere with that. I am not even sure what he is going to do.
Judge? Hang on, let Mr. J finish his point, sir.
I'm not sure if he's going to be testifying to battered...
Judge? Hello?
Mr. Owens, we can hear you loud and clear, sir.
Oh my God.
Judge?
Yes, sir, we can hear you.
Judge?
Mr. Owens, I can hear you.
Judge?
Sir, I can hear you loud.
All right, everyone. Let's take a couple deep breaths. Okay.
Clear, sir.
Judge Kramer?
Yes, sir, we can hear you. I can hear you.
Judge Kramer?
Mr. Owens, I can hear you, sir.
Judge Kramer?
I can hear you.
I can't hear you. I can't hear you.
Only the penitent man shall pass. Only the penitent man shall pass. Only the penitent man shall pass. Only the penitent man shall pass.
Judge Kramer?
I can hear you. I can hear you. I do not know why you cannot hear me, sir.
Judge?
Can you hear me?
What am I doing wrong?
We're gonna call it. You're not able to yeah, but we just want there.
Judge Kramer?
I can hear you.
I will take note of two things. One, there was a time not so long ago when remote or Zoom appearance in court was not a thing. Two, if I ever become a judge, I am strongly tempted to forbid any remote appearances. We all got along fine for 1,000 years when you had to show up in person. Just because they were so busy trying to figure out whether or not they could, they didn't stop to figure out whether or not they should.
Judge Kramer?
I can hear you, sir. I can hear you loud and clear. Let me see if I can get...
Judge Kramer?
Let me see if I can get a meeting to call him and tell him that we can hear him.
Judge Clay?
And pick up, or rather than pick up where you left off, start over
So I'm just going to skip ahead 2 minutes. Great, moving on.
on the issue of, we were discussing the depositions of the recently identified experts. We had confirmed that Dr. Harper's deposition was October the 1st. Dr. Birkeland, my understanding, is no longer being called as an expert to testify, but is only being offered in some kind of advisory capacity. And all efforts to depose Dr. Brannon have not borne fruit yet. You can pick up where you left off.
Yes, we have tried to get that coordinated and have had no success with opposing counsel. I am not even sure what this person will testify about. I don't know if it's another battered spouse syndrome expert. Florida law seems pretty clear that any other mental issues would have to be insanity. So I'm not sure exactly who this doctor is. We had prayed the court for relief and at least getting a report by today from him. We have not gotten such a report. So I don't know when we will be able to coordinate that deposition prior to trial.
Okay. Mr. Owens, with regard to Dr. Birkeland, is Mr. J's position that that person is not going to be called at trial accurate?
That's correct.
Okay, all right. So is there any reason to worry about deposing that person at this time, Mr. J?
No, sir.
Okay. With regard to Dr. Brannon, are you still going to be offering him as a witness at trial, Mr. Owens?
Yes, Judge, and I'm going to be down there Monday night, and I'll be available all next week. I can do it at any time. The only 2 things I've got.
Why did the audio get like 10 decibels quieter? And should I try to fix it? So I have 2 questions. One, why is the audio like 10 decibels less loud? 2, should I try to fix it? Because I have a real bad feeling what happens if I try to fix it.
Is the Dr. Harper's deposition on October 1 and the state's expert evaluating the defendant Sarah Boone on Wednesday, October 2nd. But I'm free anytime, and we can make Dr. Brannon available any day that week. I would assume we just have to get with him.
Mr. J?
It would be helpful if I had a report so that I could craft a preparation for this person's deposition.
What is the basis to require the production of a report?
Under 320F, you in your discretion could order it to proceed along so that I do not have to engage in a fishing expedition for inordinate amount of time on the eve of a trial that is set to occur on October 7th, when I am unavailable on Friday next week due to an insanity placement hearing in Osceola County that has been previously scheduled and rescheduled numerous times. I am not opposed.
God bless whoever made closed captions of this. I assume that was someone at Court TV, and I don't know who you are, sir or ma'am, but God bless you.
Opposed to working on Thursday, but Thursday is a court holiday, so we will have arrangements. And then Wednesday.
If there are other persons in the media who are appearing virtually to observe this proceeding, I need you to mute yourself, please. There's an individual by the name of Blue. Sir, I need you to mute yourself in order for the court to conduct its business.
Actually, an argument is actually to the stand of court.
To produce a report efforts to coordinate
Deposition as soon as possible.
Do we know Dr. Brannon's availability?
I can try to get you on the phone now, Judge, if you'd like me to.
Any objection to doing that?
Dr. Brannon's on the phone. We'll have a deposition.
Guys, if the trial is going to be like this, I don't think we're going to be able to cover it because there is no way. I love you guys. I love you guys, and I'm willing to do a lot of things for you. I really am, but I'm not sure if the audio is going to be like this, there's any way on this earth I'm willing to sit through 8 hours of this. I may cause harm to myself, and we don't need that. We don't need that.
Mr. Owens, camera in here, there's no need for anybody else to be on the line except for Mr. I can't control that. The media reached out to court admin today and said they were going to appear virtually. I'm trying to log into my app to silence this other stuff. I'm having difficulty. I'm with you on the difficulty scale. And I sympathize with it, but I don't have the ability to remove him at this time. I'm working it right now. My preference to do it in person. Fine. That will be an in-person deposition no later than Thursday of next week, the 3rd. If you are unable to have that deposition coordinated, you need to let my office know immediately. We will set a hearing as necessary.
Why on God's earth? Why on God's earth are there 750 of you watching this bullshit? Do you not like yourselves? Do you not like yourselves? It's okay, guys. You don't have to hurt yourselves. Self-harm isn't good, guys. Holy shit.
I'm in trial next week, but I will make the time in order to make that happen.
Living or working as listed on the witness list in South Florida. So under the rules, the deposition should have to occur there, unless Mr. Owens is requesting a different location.
Mr. Owens, are you requesting a different location other than South Florida versus the location of Dr. Brandon?
Well, we'll ask Dr. Brandon, but if he's willing to come up here to the deposition, I'm fine with that. Or we can travel, whatever. We can do it by phone or Zoom. I'm available.
This is an awful lot of words for we'd like to be able to talk to the witness in advance. So when can we do that?
Like I said, all week next week, I'll do whatever is necessary to get the case resolved.
It's going to be an in-person deposition, so the issue is simply location, whether it's in South Florida where his office is or here.
Doesn't matter to me.
Okay. Then you've got...
Also, once again, without me doing anything, the audio has now dropped again an additional 10 decibels. So now we're heading around -40 for some reason. So now the court audio is 30 decibels softer than me talking without me changing anything. The audio level just changes again. At this point, it's going to be silent before too long. Damn. Oh, -45, even worse.
I have reviewed the state's responses to multiple matters, including the amended exhibit list and the second amended exhibit list, a response that the state had filed regarding a second motion. Was there a second motion to suppress that was filed?
Late last night, contained within that objection to the state's evidence was basically an unfiled, legally insufficient motion to suppress statements based on a statement made to a patrol deputy prior to the first statement to the detectives in an unmarked patrol car on February 24th, 2020.
I have not seen, that hasn't cleared the court file yet, I don't believe.
Judge, I believe I sent it directly to your JA. Defendant's objections to plaintiff's exhibit list. Would have been sent to Ms. Darius?
I have it.
Last night.
Mr. Owens, the second paragraph of the second page of the objections seemingly refers to a different interrogation than what is made reference to in your motion to suppress of September 24th.
That's correct.
Okay?
May I be heard?
And you filed your objections. As of right now, there's only one pending motion to suppress. Is there another motion to suppress that's going to be filed?
I'm not sure, Judge. I had some time constraints on filing this defendant's objections to plaintiff's exhibit list. I'll put those last two paragraphs in page 2 on there for the purpose of preserving that issue because my client asked me to. Whether or not I'm going to file those or not is an issue that will be decided on Monday when I drive down to speak with her. I may or may not file those, but I wanted to preserve that potential issue. Object.
Any further response to that, Mr. J? He's not responding, he's just arguing. To be able to know until you meet with your client on Monday as to whether or not you're going to file a motion to suppress. We're rapidly proceeding to trial in this matter.
Filing these defendant's objections to plaintiff's exhibit list. Based on my last discussions with Ms. Boone, she expressed concern about those two statements that are on the second page, the last two paragraphs. I simply was preserving the right to make an objection on the two exhibits, which is the body camera of Bethany Rodriguez and the audio tape that was taken, the interrogation that was taken in the squad car by the two homicide detectives. I don't know whether I'm going to even file a motion to suppress.
Okay, so long story short, in addition to the interrogation that she did, when she was sitting down at the police station, there's also additional tape of her talking to the police, one of which was in the police cruiser, and one of which was some other instance, which I didn't hear and I don't really care. They've previously moved to suppress the statement given at the police station on the basis of Miranda. My legal analysis is get wrecked. They're now contemplating the possibility of moving to suppress the statements made to the trooper in the car and wherever else they were made. Without even knowing what they are, my legal analysis is get wrecked because Miranda doesn't apply and whatever. And also procedural defaults because it wasn't filed timely. And the lawyers all over here are like, I haven't decided whether or not to file. Just fucking file. Just file. If you don't know whether or not to, just file. There's no disincentive really to file. It's not like you lose something by filing. You're not trading anything. So it's like, geez, I can't figure out whether to move to suppress these statements or not. First of all, you're going to lose. But if you want to do it anyway, then just file. And then if you change your mind, then unfile. It's like I'm dicking around about whether to file or not. Just file. Just file the thing. Oh my God. Oh my God. And then the court can tell you to stuff it. But the court's going to tell you to stuff it for procedural reasons instead of substantive reasons.
On those two paragraphs on the second page. I plan on driving down Monday. I will see her Monday night. We'll make a decision at that time.
Just file. Just file. That is not how that works. You had a filing deadline, sir. I think it was yesterday. You can't file with like, oh, I'm filing to preserve the issue. You can't do that. You're trying to do a string motion. And if you were in my court and you tried to do a string motion, I would get off the bench and beat you to death.
So many people that are trying to participate virtually. Okay. The clerk is going to call you right now, sir. Okay. I apologize, Mr. J.
I understand.
I mean, he's going to lose on the substance, but like it wouldn't be frivolous. I mean, I don't know whether or not I do as a defense lawyer. I've never really worked criminals, so I don't know. Also, it's not my preferred thing, but like it wouldn't be frivolous, and if it actually like trying to file a whole bunch of motions just for the sake of filing motions might actually buy you time, which is the one thing you really probably do want. Now, the court's probably not going to fall for it, but, you know, if you throw enough bullshit at them, you know, that's like, you know, you can argue to the Court of Appeals that they didn't really give you a chance to hear you out and there was error. So, like, filing motions for the sake of filing motions on a bid to get time, like, first of all, one of two things is going to happen, right? Either the court gives you time, which is a win, or they don't give you time, and you can try to argue to the Court of Appeals, hey, the trial court didn't even try to hear me out. They didn't even give me a fair shake. So you got an argument at reversible error. So just file the bullshit. As long as you have a colorable argument, and you have a colorable argument, as long as it's not frivolous, give it a shot. Maybe you give the appellate lawyer something to work with. You know, I don't know. You could try.
Mr. Owens, can you hear us?
Yes, I can.
All right, very good. All right. State what, if anything else, with regard to the objections as raised, making reference to another potential motion to suppress.
Judge, the state's entitled to pretrial rulings on all of these issues involving constitutional rights being violated. If the court gives the state an adverse ruling, we need the ability to file a petition for a writ of certiorari because we do believe these statements are crucial to the case. And as I outlined in one of my responses that I filed today, there is a uniform pretrial order that was issued in this case, as in every case, which clearly spells out to the defendant that she has to file all of her pretrial motions 10 days before a pretrial conference and get them heard. And here we are at the time of the pretrial conference, and we're still kicking this can down the road as to whether or not we kind of maybe sort of might.
I'm with the state, man. I'm with the state. I'd be pissed too.
We're just asking for them to file it, and if they're not, then perhaps we will do something so that we can get a pretrial ruling.
I'm with the state, man. There are rules, man. There are rules, man. We live in a civilized society, man. There are rules. I'm with the state on this one. Damn. You know?
So that there's not an adverse ruling during trial, which the state can seek no relief from. I don't think we're asking for much. It's been over 4 years. She's been well aware of her statements. She's gone through numerous counsel. It's not unfair to ask the court to get an answer. Are we going to do this? Because if so, when are we doing this? We can't do it.
I'm with them. I'm with the state, man. It's like there are rules, there are deadlines they didn't file. Go to hell. I'd be stronger than the state than this. Actually, I'd be stronger than the state. If anything, the state's response is too timid for my taste right now. I'm like, yeah, I'm with you guys.
Next Friday. We can't do it next Thursday, as far as I know, unless you can get Judge Munyon to open up a courtroom. And then we will have to deal with, are we in South Florida? Are we doing a deposition of this late expert? What part of the day? And then Wednesday, we already have the bulk of our middle of the day consumed by going out to the jail, which will probably take from about till 10 a.m. till 3 p.m., going from travel from here, getting through the screening process at the visitor's entrance, and getting back to the female dorm, and then reversing that process. And then we have the deposition of their expert on Tuesday. So we're kind of running out of time to do these things and to coordinate and make sure that the two detectives.
I'm with you, man. I'm with you. Like, we're trying to cram a whole lot of shit here in at the last minute, and the defense is apparently trying to dick around with deadlines. As we're trying to like get witnesses in at the this is procedurally nutso. We're still doing depositions and we're still doing discovery. In a homicide case 10 days before trial. This is ridiculous. This is absurd. It's like, this is, and the state doesn't want to move the deadlines, and I don't blame them. It's like, I want to get this thing done too. It's like, I don't want to move for a continuance, because that's probably what they're trying to get me to do. It's like, I'm going to make this work. Despite how bullshit it is, I'm going to make it work because I'm a good attorney. I'm going to make this work despite all the constraints. But they're still trying to dick around with me. I'm not falling for it, Your Honor. This is some bullshit. I'm with the government on this one. This is some bullshit, Your Honor. Yeah.
And now potentially this patrol deputy have availability when they were never asked.
What's the writ of certiorari again? If the state loses a motion, the motion is to suppress. The motion is to suppress. They want an interlocutory appeal if they lose. Right? That's what they're asking for. They want an interlocutory appeal. Apparently in this context, it's a writ of certiorari. Whatever, it doesn't matter. It's just a nomenclature thing. They're asking for an interlocutory because the state can't appeal if they lose, because double jeopardy, right? So they can't appeal if they lose. So the only way they can appeal is interlocutory. They can't wait till the end of the trial, because if they lose, they're done. So they're like, we want an interlocutory. If you rule against us and you say these can't be used, we want to appeal. We want to appeal because otherwise we have no relief. We can't wait to the end of trial because then it's just over. So that's what the writ of certiorari is. They want the right to appeal an adverse ruling because they have no remedy otherwise.
Made available next week. They've been asked to be made available for the 3-week trial period. So I don't think we're asking for much to just get an answer. Are we going to do this motion to suppress? And if so, when? We already have a motion to suppress issue to deal with the 2-hour and 6-minute interrogation, which is going to take probably about 4 hours between testimony from the witnesses, the court watching the full 2-hour and 6-minute interrogation, and then arguments of counsel.
Anything further, Mr. Owens?
Dealing with my motion to suppress statements, I don't think it's going to be necessary for you to watch the 2-hour and 6-minute interrogation.
I don't think it's necessary either. I don't think you need to watch the interrogation to determine whether or not the Miranda warning was sufficient. Why would you need to watch the interrogation to determine whether or not the Miranda warning is sufficient? There's no reason to watch there's no reason. You can make the determination based on the Miranda warning. You don't need to watch it. You should be able to make a decision like that.
Again, on the issue of the pleading that I filed regarding my objections to the exhibits, it's the same response I gave before. I essentially felt like I needed to file them. I don't know whether or not I'm going to file any motions to suppress on the Deputy Rodriguez's body cam. I'll know Monday night.
As a state, I'd be so pissed. I don't know whether or not I'm going to file motions to suppress on the body cam. I'd be as the court, I'd be like, you're not filing the motion. It's barred. Go away.
I don't know if I'm going to file a motion to suppress on the interrogation in the squad car. I'll know Monday night. I was simply preserving that issue that we wanted to object.
Bullshit.
On that.
Bullshit.
We're working as diligently as we can. I understand that Ms. Boone has had the case for 4.5 years, but I have not had it for 4.5 years.
Well, that's just too fucking bad. That's just too fucking bad that you haven't had it for 4.5 years. The court made it quite clear that choo choo, the train is moving. Fuck you. Right? The court made quite clear, choo choo, the train is moving. Fuck you. And you decided to hop on board the train. And now you're all sad because the train is about to run off the cliff. Well, what'd you think the fuck was going to happen? Choo choo, motherfucker.
To comply with the court's order to be ready for trial October 7th and still protect my client's rights as I see fit.
You're going to have till today to file that motion. You can buttress it, you can amend it, you can provide case law. The only thing I'm going to ask is that you provide the court and state attorney's office any case law that you plan on relying on, but you can always withdraw it if you need to.
That's what I said. That's what I said. You could just withdraw it. This isn't what I just said. You could just withdraw it. What do you mean? You just file the thing. Just file it. You could always change your mind the other way. What the fuck?
Ms. Boone.
Would you clarify that again, Judge? So I've got until the end of business today or the end of the day?
Any responses to that, Mr. J?
It makes no difference to my weekend at this point, Judge.
Okay. You'll have till the end of the day, sir, no later than 11:59 tonight to file that motion if you're going to file it, because the state needs to be advised as to what, if any, positions you have with regard to those matters.
Oh, the judge gave him to the end of the day. Judge is a pussy.
And you're referring to the motion to suppress the statements made during the body cam of Deputy Rodriguez, and then a separate motion to suppress any statements made on the audio tape of the interrogation by the two homicide detectives in the squad car. Am I correct?
I am referring to the paragraphs that are in your objections. Second page, first paragraph, and second paragraph.
Yes, sir. I understand.
If those are filed and when those are filed, I need you to favor copies to my office, please.
Yes, sir.
Now, regarding the motion to suppress that was filed on September 24, I understand next week's very busy. I know that my office had inquired if anyone was available Friday. I now understand the specifics as to why Mr. J is unavailable on Friday. As the parties are aware, the court, this is not the court's only case. The court is in trial next week. We have a legal holiday on Thursday. I don't believe that Judge Munyon has the ability to open up the courthouse just for me, as this is a statewide court holiday. That would be required of the Chief Judge of the Florida Supreme Court, I think, to make that decision. And I don't know that I have the ability to call Chief Judge Muniz to get that decision by Thursday to allow us to conduct work on that time. I will make myself available next week, but the problem is the scheduling of it, because the court is in trial, and the state certainly deserves an opportunity to understand the court's ruling prior to trial in order to prepare what, if any, rulings would be adverse or for the benefit of the defense or for the state. I don't know, because I haven't had the hearing. With regard to the 4 hours, Mr. J, why could I not review that 2-hour and 6-minute interrogation prior to the hearing, such that we would be able to save some level of judicial efficiency and economy?
I have no objection to the court doing that. I just understand that some judges in this building do not do that.
I don't have a problem looking at it in advance, and that way if there are certain things that either yourself or Mr. Howens wants to highlight for me during the hearing, look at time step X or Y, certainly I'll give you both the opportunity to do that. But I think for judicial efficiency and economy, I don't have a problem reviewing it so that we don't have 4 hours of hearing time. Maybe we limit it at 2 for the purposes of case law argument and any testimony.
Judge, if I may.
Yes, sir.
If I may. Friday, I know there's two prosecutors on this case. I understand that this prosecutor is going to be elsewhere, but either the main prosecutor who's prosecuting this case that would be available Friday for a hearing on this issue about my motion to suppress.
I'm handling the motion to suppress issue.
Okay, that answers that question, Mr.
Why can't I just rule on that? Why can't I just rule on the motion to suppress? Look, I already know everything there is to know. I don't need to know anything more. What more do I need to know? I already know everything. You're mad that they didn't ask the last question. Do you have any case law that says the question's required? I know you don't because you didn't cite any. So motion denied. Why can't I just rule on it? I know the answer. Put me in, Chief.
Jay's handling it. So I am here at your disposal, gentlemen, for when we might be able to set this motion for hearing.
Judge, if I may, we've been in contact with Dr. Brannon, and he is available on October the 3rd at 3 p.m. I'm just waiting on a location from him, but I believe, Judge, that's Thursday at 3 p.m. That's the holiday. So I'm available that day. We just got to check with Dr. Boone about which location, whether Orlando or South Florida, where his office is.
State's not willing to go to South Florida for a 3 p.m. dep on Thursday when I need to be ready for back in town and get a good night's sleep before doing the insanity placement hearing on Friday morning. So he's not willing.
Mr. Owens, hang on, please.
He's not willing to do it up here, then we'll need to coordinate another time during the week.
Okay. 3 p.m. is not going to work based on the state's schedule and what they have to take care of on Friday.
Okay, I'll try to get him up here for that date and time, October the 3rd at 3 p.m.
Are you stipulating? Are you stipulating then, Mr. Owens, to having Mr. Brannon appear in person for the October 3rd at 3 p.m. deposition here in Orlando?
I can't stipulate without talking to the doctor first, but I'm going to make every attempt to get him up here. But I'll let the court know, hopefully this afternoon, and the state know this afternoon.
Okay. All right. Getting back to the September 24th motion to suppress. State, how can we tee this thing up for hearing in time, understanding
Just rolling it.
Pocket on the 4th?
Just rolling it.
Judge, I'm available Monday. It's my understanding that opposing counsel will be in transit to the Orlando area on Monday, so I don't know of his availability. On Tuesday, we are taking the deposition of Dr. Harper from 10 a.m. until I'm concluded with that deposition, but we should have afternoon time, especially if it's only going to be 2 hours on Tuesday the 1st. And on Wednesday, I can make myself available to do it at 8:30 in the morning with the court prior to us getting ready and going out to the evaluation at the jail, or we could do it afterwards at 3 p.m. on Wednesday when we are done at the jail.
But 3 p.m. is when the evaluation concludes, correct?
She says 2 hours, but what I'm trying to include into that is leaving the female dorm, getting back to our cars, driving up I-4, getting to the courthouse.
Okay, so that's a 3 p.m. ETA here?
Yes, sir.
Okay, got it.
Judge, my only concern is I know the two homicide detectives, I anticipate the state being able to have them available whatever day, but I do want the custodian of the records to bring from the sheriff's department, so I have to subpoena them to bring the policy and procedures of the Miranda card and the waiver of rights form under the Miranda.
Any response to that? Okay, all right. We'll make it happen on Wednesday. I'll advise the ASA and the defense in the trial that's set for Monday that we're going to have a hard break at 3 o'clock on Wednesday. If we have to work a little bit after 5 o'clock, I will let my court staff know that we may have to work a little bit later that evening in order to make that hearing happen. State, are you going to be able to subpoena your witnesses in time to get them here?
They will come.
All right. Defense is Wednesday at 3 p.m. acceptable? Mr. Owens?
Yeah, I'm here, Judge. I'm sorry.
Wednesday, October 2, at 3 p.m. for a hearing on the motion to suppress.
Judge, I'll work on getting my subpoena out today.
You know, not for nothing. Although I think the state should obviously win this because, duh. But they're going to have a hearing on the 2nd on the motion to suppress. So, even assuming we rule from the bench, which is one hell of an assumption, how the hell are we supposed to get to the Court of Appeals and back in 5 days for review of the denial? You know, in the event the state loses, how the hell are we supposed to get to the Court of Appeals and back in 5 days? I don't think the Court of Appeals is going to be really happy with that idea. They're not used to usually to working that fast. Yeah.
For the motion to suppress Wednesday, October the 2nd at 3 p.m. Eastern Standard Time.
Correct. At that point in time, we'll also address the motion that was filed at 1:13 this afternoon regarding clothing, etc., for Ms. Boone. I conferred again this morning, Mr. Owens, with Barry Click, the Public Defender's Office. She has not heard from you yet. Are you going to be relying on the Public Defender's Office to provide clothing? They are still ready, willing, and able to do so.
No, Judge, we were going to provide clothing for Ms. Boone.
Okay.
We wanted to get out there one day, early, Tuesday probably, to take measurements from her.
That's something you're going to have to address with the jail.
Okay.
I know I saw your motion. I don't even know if the state's had the opportunity to review it yet.
I have. I believe the shackles portion of the motion has been a ship that has come through here and sailed, and I believe all the clothing issues have been addressed by the court. The only thing that seemed to be new was the hair and makeup, and I did not see any authority cited that specifically said that was permissible. But we don't really have a dog in the fight. If court admin and security staff, however it works, is going to permit this to perhaps, as far as I know, be the first person to ever have that in this courthouse, that's between them.
Okay. All right. So the court will review that motion.
I love it. We're going to get a little makeup chair in the courthouse. That'll be good. We're going to get a little makeup chair so she can get ready for her moment. The state's like, we don't have a dog in this fight. We don't fucking care. I like that response. I like that response very much. I like that. It's very good. We don't have a dog in this fight. We don't give a shit. If they want to put out a chair and, have her made up in the courthouse, that's fine. You guys fucking figure it out. I love that. That's good. I approve. Plus 1 point. That's good shit.
And the case law that you provided for me, and I will make a ruling on that in chambers as soon as practical. State, is there any other housekeeping matters or anything else from a scheduling perspective we need to address today?
There just appears to be a lot of discovery that is still outstanding, and that discovery includes medical records from several different locations, and things, those specifically, and perhaps other things that are probably pertinent to all three of the experts, the two defense and the state's expert on battered spouse syndrome. So I don't know how we want to handle that, because if this information finally does come in, and again, I believe the court has already accepted the state's arguments that once jeopardy has attached, then it's too late. But there comes a point in time where it's too late for us to get this new information to all three experts. And
you think?
Close them as well.
Yeah, that'd be a little bit tough.
There is my concern with this outstanding discovery.
This is like trying to squeeze. This is the ultimate cram. Like this is the worst version of trying to cram for your finals I've ever heard of in my life. It's like we're trying to get experts, and more than one from the state, and we're trying to get them deposed. And also, of course, to the extent of what they say, we might have to then talk to our own experts, which might then require further deposition. So we're trying to coordinate. I don't even know how many cats at this point. It's hard to keep track. How many cats were even trying to like coordinate at this point? And we're trying to do it all within the space of what? The length of a song? It's like how Someone is going to turn old and gray over at the prosecutor's office before this is over. I swear to God. Miss Boone may yet have one more fatality under her belt before this is over. Because someone at the prosecutor's office is going to die. This is yeah, good times.
Mr. Owens, any response to that?
Judge, we'll call today to see where, if the medical records are en route. We'll get the state an answer today, one way or the other.
Okay. Get the state an answer today, one way or the other. But if it's Friday next week and you get them, that could be problematic as to whether or
You
not
think?
they're going to be permitted.
You think it'll be problematic?
I'm not saying no. It's just.
You think? If you get it to them next week, when trial is the Monday that follows, trial is Monday next. Trial is Monday next. You think it might be a bit problematic to get them discovery regarding an expert that late? I think it might be problematic too. Yeah, that would be a little bit difficult. I'm sensing some problems.
The limited opportunities we have for everybody to understand what those records are.
Judge Clayton, we're doing the best we can.
I understand that. Anything else from a scheduling perspective, state? Mr. Owens, anything from a scheduling perspective from your side of the ledger?
I don't believe so.
Okay, all right. Are there any other matters with regard to trial that we need to address starting on October 7? Jury selection is going to be here in 12 Alpha. I outlined previously the amount of people in working with jury services that I'm going to be bringing in. The court's druthers are in the morning to have 50 people, address any preconceived notions or knowledge about the case, and cause challenges as to our jury sacrificing 3 weeks out of their life to come participate in this process. And for those that may be able to do that, I will give them a number, or Madam Clerk will give them a number for jury services to call for when they're supposed to return. I then intend on having another panel of 50 at 1:30 that afternoon. That will continue until we have a panel of 40 to 50 persons for which to select our jury from. Does the state have any questions with regard to that process?
Nope.
Mr. Owens, do you have any questions with regard to that process?
Judge, are we going to be in a bigger courtroom than the one you're in now?
No, sir, but we can fit 50 people in here. In the gallery, I can fit 50 prospective jurors. And I've already coordinated with the sheriff's office to ensure that we'll have the appropriate number of seats in order to make that happen.
Okay.
So any questions with regard to that protocol?
No, sir.
Okay. All right. Anything else that we need to address, state, from your side of the ledger?
Just that based on the battered spouse syndrome evidence, we are, as well as the defense, working hard to get everything in rebuttal put together for that. I believe they have listed all the patrol deputies for the prior interactions that the defendant and the victim had in this case. We're going to be listing those as well. So I don't think that would constitute any surprise or great shock. But other than that, I think that's all the state has.
Okay.
So we are also putting the defense's witnesses on our witness list. So they're arguing battered spouse. They apparently have some troopers that apparently are going to testify to something. Defense has called them. And so the state just said, okay, well, we're putting them on our witness list too. Just FYI. Cool.
All right. Anything else we need to address from your side of the ledger, Mr. Owens?
Just some discovery issues, Judge, but I think we need to deal directly with the state on those.
And discovery issues, what are you referring to specifically, just so that I'm clear?
Well, there's a public surveillance video from Publix that we cannot get to play. We received it from the state, but we requested new videos or a specific program, but it will not play for us. I assume that
VLC, man. VLC. When your video doesn't play, VLC, man. They don't have the right codec. They're boomers, man. They're boomers.
that's the one either where Sarah Boone and George Torres will go into Publix the first time, and there was a second time that just George Torres went. So we're trying to get that. I think we're trying to get an updated address on Melissa Sexton, which is a witness that I think is listed by both the state and the defense. And then we have an address for a Deputy Zito that's a P.O. box. We probably need a better address from that. So just some stuff that the state and I can get together on and try to resolve.
Okay. All right. Anything else, State?
No, Your Honor.
All right, Mr. Owens, anything else?
I don't believe so, Judge. We're going to do our best this week to get all this resolved and be ready for trial October 7th.
Okay. We will see you next week on the 2nd at 3 p.m. for hearing on the motion to suppress.
This is so absurd. We're having a motion hearing on the 2nd with trial on the 7th. This is just ridiculous. This whole thing is ridiculous. This is, and that
Number 24, and for trial on October the 7th. With that, court will be in recess. Thank you all very much.
Thank you, Judge. Bye-bye.
all right, my friends, that brings us to the end of the hearing. So, of course, she gets her civilian clothes because, to do otherwise would be unduly prejudicial. So, of course, she gets her civilian clothes. And as for hair and makeup, if you guys can figure it out at the courthouse, apparently knock yourself out. The state has no dog in this fight. If you guys want to do a little makeup session at the courthouse, go nuts. We don't care. Works for me, man. We still have expert witnesses. The defense didn't file stuff timely, but they're allowing them to file tonight on whether or not they're going to move to suppress these other things or not. I would have said it's time barred. Also, I think it's a fairly simple legal issue, to be honest. Either the Miranda warning is sufficient or it's not. Either that statement is required or it's not. There's no case law that says it's required. So, go away. Also, I would also say that Miranda wasn't required in any event as a subsequent argument because she wasn't under custody. She came down there voluntarily. She drove herself. She came into the back room. She was free to leave. So it wasn't even required. So it wasn't, even if it was defective, it doesn't matter. And so it's easy to win on the state's theory. So, but we still got expert witnesses, including another doctor who may or may not be there to testify about battered spouse. The state isn't even sure. And we got to schedule depositions for these people so we have some idea about what they're going to talk about at trial so, we can prepare accordingly. And then, of course, we could potentially have to talk to our own experts, and we have to get this all squared together by the 7th, and basically it's because we need to be ready to go. So the whole thing is whatever, man. The whole thing has been whatever. There are docs for review. What kind of docs are there? Oh, Sarah's, of course, getting evaluated next week by the state's expert, which they have every right to do. They've put their mental health in issues, so the state has every right to have them examined by their own expert. Yeah. They are screwed on the time crunch. Yeah, this is pretty absurd on the time crunch. This is pretty absurd on the time crunch. They're screwed, yeah. The time she didn't even remember going to Publix, yeah. Yeah, maybe she was confused because she was trying to order something at Denny's. I don't know. The judge is slightly nicer than me, but only just. Yeah, I feel that. Yeah, I feel that. All right, guys. Well, is there anything more or should I just sign off? They provide the bright cherry red lipstick and blue eyeshadow. Yeah, maybe. Our stylist is going to troll her? Yeah, maybe. The sound is going to give you a migraine. We made it through together somehow. You and me, we made it through. Yeah, I think that's about it, Tony. I think you're right. All right, let's see who I can dump you over to. Let's see. Who's streaming? Is anyone streaming? Donnie is streaming. Is anyone else streaming other than Donnie? I can send you over to Donnie on direct. I'll send you over to Donnie on direct. I'll send you over to Donnie's way. All right, have fun over at Donnie's channel. Remember, be nice. As always, say hi, be nice, be supportive. Until later, my friends, I've been on Civil Law. I hope all is well, my friends. Until later, goodbye and ciao.